shortly. Please make sure cell phones are turned off completely. Thank you. Courtroom's ready. Court, all rise, please. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, for and within the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session.
Hey, good morning.
SJC 13816, Commonwealth versus Jose Arias.
Hey, Attorney Warren.
Good morning, and may it please the court, John Warren on behalf of Mr. Arias. We are asking that this court reverse the motion to suppress in this case. Under the touchstone of Article 14, what the police did here was not reasonable. It was not reasonable to use the traffic infraction from a full day earlier as a pretext to stop Mr. Arias. And it can't be the case that Mr. Arias' driving on Market Street was criminal and arrestable, where all he did was travel 1 block and attempt to turn left at the first available side street off of the congested Market Street.
What's the limiting principle? How long can the police wait to actually issue the traffic citation? Or actually to stop you for the traffic violation?
Right, so I think under De Vega, which adopted Mendonca, the federal case, it comes down to a balancing of the government interest versus the individual interest. And so here in Mendonca, it was 1 hour, and the court there said that was a lengthy delay and it was unreasonable. Here we have a full day. And on top of that, the stop was, like in Mendonca, the stop was pretextual. And what the courts in Mendonca and De Vega said is that where the stop is pretextual, that raises the individual's interest in being free from a stop that is pretextual. In other words, the police can't just take a traffic stop, put it in their back pocket, and pull it out whenever they decide that they want to make a pretextual stop.
If it hadn't been a pretextual stop, is there any other reason why this 1 day delay would have been unreasonable?
Yes, I do think that any sort of delay has the potential to be unreasonable based on the facts, and it could be the case that a stop isn't pretextual and there's a certain amount of delay and that it's nevertheless unreasonable. But I think when the stop is in fact...
I'm asking about this specific case, not about abstractions. In this case, your client drove in a area of the street that is not a travel lane for vehicles, for motor vehicles. Passed people on the right, and then turned left in front of them. It's a serious traffic violation. It's not like speeding 3 miles an hour above the speed limit. And so I'm wondering what would make a 1 day delay in stopping a person who committed that kind of traffic violation, assuming, as I think we have to, that the judge credited the officer's testimony that there was no safe way to effectuate a stop right at the moment. What made that stop unreasonable if we remove the element of pretext?
So, to Your Honor's point, the judge did not find that the Officer Peerway, couldn't have followed his normal practice, which was to call in a marked unit because he was undercover. The judge made no specific finding on that officer calling a marked unit to make the stop. And where it was the Commonwealth's burden at the hearing to establish that this was a reasonable stop.
We can make some, I think, conclusions about what the judge's findings, implicit findings were. But so I don't think that's your strongest point. probably good. Maybe you could answer my question, which is what would make this unreasonable apart from the fact that it was pretextual the next day? Do you just not have an answer to that?
No, it's unreasonable because the police had opportunities to make the stop, not only that day. I do think the judge didn't make any findings on that. The officer, Pirouet, was asked at the hearing, why did you not call for a marked unit? All he said was one word, safety, without any elaboration. That's a conclusion. The Commonwealth did not elicit the facts as to why he didn't make the stop right then and there. But then you go to the next
But I
day.
think the question is really like in the abstract. If I'm a driver, I pull over into something that's not a travel lane. I make a left turn in front of all these people who are appropriately stopped. Is it okay for the police to come knocking 24 hours later? What makes that unreasonable if they're not doing it on a pretext?
So I think drivers would expect to have a traffic infraction dealt with right then and there. And to the extent that it's not, it's the Commonwealth's burden to sufficiently explain why there was a delay. And that simply didn't happen here. And it's not just Officer Pirouet in the moment and an insufficient explanation as to why he didn't make the stop. It's then the next day, Detective Feeney, who's working with Officer Pirouet, is back at that address in Brighton, camped out again behind the vehicle.
So if Feeney made the stop the next time they saw him, according to the record, that would have been reasonable?
It would have been more reasonable than Officer Feeney watching him leave the address, walk to his car, and not go up to him and hand him the citation and deliver him the citation. And in fact,
How do we write this opinion? Let's just say we agree with you that there's some limiting principle. You just sort of the rule of reason, totality of the circumstances.
I think it's a
What you're
balancing,
suggesting?
right? So if you were to write the decision, a balancing of the government interest versus the individual interest. And here, where we have a full one-day delay, where we have the fact that it was a pretextual stop and not even the real reason that they stopped Mr. Arias, and you have police opportunities before they actually effectuated the stop to deliver Mr. Arias the citation, which in fact they never actually gave him or wrote.
Importantly, on government interest balance, and the government interest has to do with the safety protections of the traffic infraction itself, correct?
Correct. And
how does that play out here? Right.
well, here I think it plays out similarly to as it did in Mendonca, where the driver was going 90 miles per hour on the highway, was trailing other vehicles too closely, was changing lanes without signaling. The point is that if the traffic safety infraction is such that it needs to be addressed by the government, then the police should make the stop. And if they don't make the stop, they should come in and explain why it was reasonable to delay, and that simply didn't happen here.
Is this an exception you're proposing to the authorization rule, or is the authorization rule grounded in reasonableness under Article 14?
I would suggest it's the latter. And I think what's interesting about De Vega and Mendonca is that those cases take into account the nature of a stop being pretextual, because that goes to the government interest versus the individual interest in this balancing.
So when it's feigned government, when we're looking at the real government interest that they professed at the time of the stop, that's what's really going to diminish their governmental interests and safety concerns over the traffic violation.
Correct. And so this court, under De Vega and Mendonca, could decide this case without touching, whether pretextual stops are improper under Article 14 on the whole, because the idea of a pretext plays into the balancing between the government interest and the individual interest under Mendonca and De Vega.
But don't we usually judge the officer's conduct at this stage from an objective standard as opposed to a subjective standard about what their intent was?
Generally, I think that's true. However, I think under De Vega and Mendonca, it's clear that
De Vega discussed Mendonca, but it is a different case, and it didn't. I don't think it was dicta to the extent that it addressed this kind of situation with respect to Mendonca. It did repeat some of Mendonca, but it doesn't seem to me that it decided that in Massachusetts we take into account pretext.
Sure. I think to the extent it doesn't, then this court should take into account pretext insofar as it bears on the individual interest, as the court did in Mendonca.
Can you address a little bit the spectrum that we have. There's the Sixth Circuit case that's discussed in De Vega, where the officer knew that the person didn't have a license, or I think was driving without a license. And so it was what the Sixth Circuit referred to as a continuing violation. And there was a lot more justification to stop the person a day later. And then the far end of the other side of the spectrum is, of course, De Vega, where the violation was just literally blocking traffic that was completely resolved, this court noted, once they moved the person along. It seems to me that this falls in the middle category because it's a really dangerous maneuver that is reckless, and traffic citations have two purposes, right? In the moment, they potentially identify whether a person is drunk, whether, they stop trying to address the behavior at that moment, but they also have a deterrence purpose, do they not?
So I would suggest this is much more like De Vega and Mendonca, frankly, where it was a single maneuver. It was a one-time incident. Mendonca actually was arguably more continuous because it was over the extended period of time on the highway. But I think this is towards the De Vega spectrum, where it's a single incident, and it's not like someone getting behind the car again with an unlicensed.
But it's harder to say in this case that the government's interests in safety were completely lapsed. Is it not?
Well, I would say that they were, and to the extent they weren't, they should have addressed it in real time or explained at the motion to suppress why it was not addressed, sufficiently explain why it was not addressed in real time, or hand them the citation the next day before you have this individual, if you're so concerned about traffic safety, before he gets back into the car again.
But where it's a reasonableness balancing, to win, you don't need to establish that there's zero government safety interest here, do you?
No, especially when it was not even the real reason for the stop.
So can you go back to Justice Wentland's rule, a question about what is the rule here that you're really asking this court to establish?
I think the rule is simply reasonableness and a balancing of a government interest, and where you have, balance the delay, look at the government interest in effectuating the traffic stop and the opportunity that the police had to address it prior to the point in which they did address it, and that's the balancing test.
Given what you've just said, does it make sense for your position to be that pretext matters?
Correct. Pretext does matter.
Why is that good for you? Why wouldn't you want to say, regardless of pretext, if it's too long a period of time, it's not reasonable?
Well, I think that goes to Justice Woldehogen's question, and I would agree with that a delay could be reasonable without pretext. I just think it matters. Because it goes to the government's actual interest in traffic safety, and it not being the real reason that they actually even stopped this person.
So I'm a little bit confused. I thought a little while ago you said that the pretext was something that was part of the calculus of the individual's interests. So are you saying that under the governmental interests, you're also using that as part of the framework?
I think it goes to both, Your Honor.
Okay. So going back to the governmental interest, though, so if the rule is in at least gauging the governmental interest, that the viewpoint is a totality of those circumstances. So in that case, if there wasn't pretext and there was a hearing, and at that point the government introduced evidence as to why they had to wait the next day, or that it was reasonable to wait the next day, you could lose.
Correct. If the explanation was sufficient, I think that would go in their favor, and we could lose.
Can I take you to the second issue? Which I'm very interested in, about how do we deal with the stop? How do we deal with the car moves slowly. The judge somehow finds it's an arrestable offense, but he doesn't make express findings about whether he could have pulled over. So, because if you win on that, again, we avoid a lot of the complicated pretextual issues, right?
Correct. There's 6 issues here. Any one of them would win the case for Mr. Arias.
Focus on that.
So with respect to the failure to stop, what happened here is Mr. Arias traveled slowly for about a block, a very short distance. Obviously, it's going to take some amount of time to realize that police are trying to stop someone and that you're the person being stopped. The judge at the conclusion of the hearing determined there was no space on the right-hand side of the road to pull over. Now, if Mr. Arias had stopped in the middle of the road, he would have blocked all the traffic on Market Street. And in fact, the RMV suggests that you're not supposed to stop in the middle of a travel lane. And so what Mr. Arias did was attempt to turn left at the first available side street, which was Bennett Street, to move out of the travel lane. And he at no point fled or sped off. He didn't try to evade. Once he was stopped by those cars heading the opposite direction, he didn't try to go around those cars or evade them.
He couldn't, right? He was boxed in at that.
He was blocked, but there was certainly no, attempt to evade those cars.
So so your view is the judge's finding that this was an arrestable offense is clearly erroneous on the facts or what?
It's twofold. It's twofold, Your Honor. First of all, there was no probable cause of failure to stop. He didn't commit that offense based on the traffic situation that was going on. And I think the implications for all drivers, if this is probable cause for failure to stop, the implications are pretty problematic. That police could take a short delay where there's no really other reasonable place to pull over and say that not only is that unreasonable, but actually that's a crime and that's arrestable. That simply can't be the case. So
they can exit order you and pat frisk you.
Exit order, pat frisk, arrest, take you to the station, and charge you with a criminal offense. That simply cannot be the situation. And so the argument is really twofold. On the first hand of it, there's no probable cause to arrest. And on the second point of it, which is the Atwater issue, the arrest itself was unreasonable. And what I would suggest this court do is reject, as many other states have done, reject Atwater and consider the reasonableness of the arrest here, where on the one hand you have a full custodial arrest, someone being taken into custody, and on the other hand, you really don't have a breach of the peace based on Mr. Arias' driving.
Do we need a breach of the peace here? Because we have a statute that makes this arrestable, right?
Correct. So that's the Atwater question. Essentially, does there need to be an Article 14 reasonableness balancing, notwithstanding the statute? And what I would ask this court to do is to reject the conclusion in Atwater, and to do that reasonableness balancing, and to consider whether there has been a breach of the peace. And here, Mr. Arias didn't do anything to breach the peace. His driving was de minimis. To the extent there was any effect on the public, that was inherent in police making a traffic stop with numerous cars and officers disrupting traffic. And I think with respect to Atwater, if this court follows the logic of the Atwater case, that this court gets to the opposite conclusion, because in Lunn, this court determined that under our common law here in Massachusetts, we require a breach of the peace to make an arrest for a misdemeanor. So
Can you just address the Commonwealth's argument that the failure to stop itself, I understand that you don't agree that there was a failure to stop, but assuming that there was, that failure to stop was a breach of the peace?
So I would suggest it wasn't. Breach of the peace is having some disturbing effect on the public. Mr. Arias is driving. He traveled slowly for 1 block and attempted a left-hand turn. That's what his conduct actually was. That didn't have any effect on the public.
Doesn't the record, it had some effect, right? Like all of traffic in that location had to be snarled up so that the police could address. I understand your argument that what he did was not reasonable and that this was not a really lengthy failure to stop. But as a matter of fact, police had to, in their view, execute a maneuver where they completely blocked traffic by Forest Hills and all the cars are piled up such that he couldn't, there was a whole snarling of the traffic that occurred. So I think it depends on how much of a breach of the peace counts as a breach of the peace.
So that the effects of him being stopped on a busy, congested 1-lane road were inherent in police stopping someone on a busy, congested 1-lane road. In other words, when you look at his actual conduct, I think you have to look at what he did. He traveled for a block and attempted a left-hand turn, and that didn't cause a breach of the peace.
And you think that it has to be specific to the particular defendant's conduct in any particular case and not a general rule with respect to failure to stop, because obviously there are numerous circumstances in which it creates a huge public safety hazard if a defendant refuses to stop.
Absolutely, absolutely. It's what I would suggest is there needs to be an Article 14 reasonableness balancing of the arrest itself.
So in every single case, police officers have to decide whether there's a breach of the peace before they can make an arrest for a misdemeanor.
More broadly, just that the arrest is reasonable in the circumstances. And I think it's noteworthy here that Mr. Arias was never even charged or cited with failure to stop. This was a theory that the Commonwealth conjured up prior to the suppression hearing. And it goes to the fact that, to Your Honor's point, if the arrest is reasonable in the circumstances, then that's fine. But I do think there needs to be a reasonableness calculus where what we have here is someone driving a block, attempting a left-hand turn. We're going to arrest this person and take them to court and charge them with a criminal offense.
Well, they strictly speaking didn't arrest him here for that because they found drugs, and that is why they arrested him.
Right. Well, that's even worse because and that goes to the final issue for suppression being pretextual arrests, which is, are we going to be okay under Article 14 with arresting someone when it's not the real reason that they're being arrested? And here it wasn't even pretextual, it was a post hoc rationalization where the Commonwealth came into the suppression hearing and said, well, this was enough here for failure to stop.
Okay, thank you so much.
Thank you, Your Honors.
Attorney Hartley.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth, and with me is Assistant District Attorney Thomas Laverty, who was the trial prosecutor on this matter, but not the motion to suppress prosecutor. Turning to the first issue, the motion to suppress was properly allowed where there was a reasonable one-day delay in initiating the traffic stop. So de Vega stands for the proposition that a stop must end when an officer observes a traffic violation but unreasonably delays initiating that stop on the basis of the violation. So the question here is, was the delay reasonable? And that begs the question, how do we define reasonableness? It's not based on the length of the delay.
Well, that's got to be somewhat, that's got to be a factor, right? Because if it's a really serious traffic offense and the Commonwealth thinks it, aren't they going to respond and get this guy off the road so he's not doing this again? So they can't just bank this for a month or...
So maybe I should rephrase it. It's not solely based on the length of the delay.
Sure.
That might factor into the reason for the issue. The question, the pertinent question is, what was the reason for the delay, I think, here? And could the officers have addressed that traffic violation and attended to the safety concerns previously? The answer here, based on the record we have and the judge's findings, is no.
Well, it's muddled, right? He's asked one question, why didn't you do anything? And he says safety. But that doesn't really make that much sense. He could, if he were really troubled by this, he could have said, I've just observed so-and-so doing this dangerous maneuver, pull him over and stop him. But that's not what, he's not bothered enough to do that.
Right? I agree, Your Honor. The record is sparse on this point, to say the least.
Well, isn't it more than because when Feeney gets them the next day, what the police say is we're conducting surveillance, correct?
Correct.
So the surveillance means, in this context, they're looking to see if he's dealing drugs during this point in time, right?
So
that's what's going on for real.
So we know there's a drug investigation,
right?
Aside from the fact that that's an ongoing investigation.
So surveillance means watching; it doesn't mean stopping, correct?
Correct. But I think those are two separate issues here. I don't
well,
think...
if the very first time they see him when he's getting into the vehicle, they decide to conduct surveillance to see what's going on, to see what's up, correct?
Correct.
And it's not just, oh, here's that traffic violator, pull him.
You mean the second day on the 28th when they, yes. But so I think that the argument that Feeney could have stopped him when he first saw him falls short here. First of all, there's nothing in the record to indicate, yes, there was this drug investigation going on. We don't know anything more about it than that. That's not part of the record. But there's nothing in the record to indicate that Feeney knew anything about the traffic violation. And I think they're two entirely separate issues here.
So I had a question about that. Did Feeney talk to Pirouet that second day?
So he radioed when he saw defendant get into the car that what he saw, and he followed him for a brief period of time, then lost him.
But he radios stop him for a drug violation.
Right, right. So that's the communication the second day. Is
So the communication from Feeney to Pirouet is what?
Is that I observed this individual in this location.
And Pirouet doesn't say in response, oh, pull him over because he did a traffic violation the day before.
No, but what he does at that point when he's radioed, Feeney says that I've lost sight of him. So Pirouet immediately goes to that location. Once he has eyes on the defendant, he then radios for backup to stop him because he's in an unmarked car. So the Commonwealth's position is that the stop, in terms of the traffic violation, was effectuated as soon as reasonably possible.
Well, what about, can you go back to the first day? Because I think there's a little bit more evidence that's relevant here. There's testimony from Pirouet that not only that this is explanation of safety for not calling a marked unit, but then eventually when pressed, he says, essentially that he decided not to stop the defendant at that point. And my question for you is, by a little bit by analogy to De Vega, was the traffic safety issue in that moment essentially resolved in a way that the testimony is that he decided, the officer who was the only officer who could cite him, because this is the officer who saw the traffic violation, decided not, the record reflects he decided not to stop him that day. And so why does that not resolve the traffic violation in the same, in an analogous, albeit slightly different way than what occurred in De Vega?
So I think first, because the reason, my reading of the record, the reason that he decided not to stop him was because of safety. He couldn't because of safety.
What is the reason why that is supported by the record or even just common sense that safety precluded calling in a marked unit at that point when it's his usual practice, which was his
So
testimony?
we don't have any testimony on that, but I think to the extent—
And it's the Commonwealth's burden, right? So
yes, but I think to the extent that the officer credited his testimony, which was it was not safe for us to stop him at that time, certainly more detail would have been helpful to the Commonwealth. But to the extent that the officer credited that, I think that's sufficient. And I think this is distinguishable from De Vega, where the court specifically talked about that violation, which was the car was parked in a street in such a way that traffic could not pass. So once the car was moved, there was no question that that was resolved. The question of reckless driving is different, and De Vega even says that this was not reckless driving. They also use the example of driving without a license.
Doesn't safety go say the exact opposite? If you're concerned about safety, you stop him. Safety has, how do you interpret the statement safety to support not stopping him? I have trouble with that.
So again, more testimony on this certainly would have been helpful, but my reading of safety was it was not safe for the police at that time. Not necessarily there was a public safety issue, which—
safe for to say, officers, pull him over, he's been driving recklessly.
Because of the traffic pattern. I mean, I'm speculating here because the record is
that a problem?
sparse.
It is a problem. And the word safety, you have it doing a lot of work here that the record doesn't necessarily support. But I want to go back to something you just said a little while ago. I think to Justice Wendland's question about not knowing what Pirouet's practice was. Doesn't it cut against the Commonwealth that Pirouet did exactly what we're all wondering why he didn't do the night before? He called the black and white, right? The next day?
I'm not sure I follow you.
The next day, when he went to the scene and saw—
Oh, he called back up and yeah.
Right?
Well,
so if he was concerned about safety, even if I give the loaded definition of safety you're giving, that he's undercover, maybe doesn't want to blow his cover, he could have called the black and white the night before.
Your Honor, and I'm not sure I'm speculating that much about whether he was undercover and he wanted to blow his cover. The testimony in the way that he says it wasn't safe, I think, has to do with the traffic pattern, and he just simply couldn't follow him in a safe way. Again, certainly more testimony would have been helpful, but I think to the extent that the judge credited that it wasn't safe for us to stop him at that time, that is a sufficient reason for the delay. And the next day when he saw him, he effectuated the stop as soon as reasonably possible. We don't have any testimony as to what the difference was on that day, why it was safe then and why it wasn't safe the day before.
Well, we do. We have his statement that there's a drug investigation, and so that's why I'm going to ask you to pull him over.
Well, but I think that's separate from the issue of why he didn't stop him the first day. And
But it's
also,
indicative of why he stopped him the second day.
so, I mean, there's no question it's a pretextual stop. On both days, the stop would have, he was following him for 6 miles, observed a serious traffic violation, and then would have, if he could have, stopped him at that point. But the pretext issue is separate. And the reason for the delay, based on this record, again, although more testimony certainly would have been helpful, is not because, it has nothing to do with the pretext.
Do you agree that the pretextual nature of the stop goes to the governmental interest?
So I don't think so. I think that what's
All right, so let's break it down. The governmental interest has to be in the government's interest in enforcing the traffic laws, correct?
correct.
Wouldn't the pretextual nature of the stop, meaning the real reason we stopped this vehicle, go towards that governmental interest?
So I think I don't think that's part of the consideration when you have a lawful traffic violation, that the police are well within their rights, as this court has said and the Supreme Court has said, to stop that individual. Now, there is this case illustrates that there is a limit to pretext.
Okay, and the limit is the constitutional consideration of reasonableness, right?
Yes, and that,
So when we said in De Vega, if this is in bottomless authority, you couldn't stop him 15 months ago. You could stop.
Exactly.
A 15-minute delay is different than a 15-month delay, right?
a pretextual, a traffic violation can't hang over someone's head infinitely. Again,
Well, actually, it can't really hang out over its head very long at all, because under the anti-fix statute, someone cannot be cited unless it's given at the time and place of the violation, unless an exception applies, correct?
that's true as well.
So how can you, so the legislature has said that the government's interests, and then I understand that their view is not necessarily exactly the same as Article 14, but the legislature has provided that no one can get a traffic citation unless it's given at the time and place, unless very specific criteria are met.
Right.
So can you address how that relates to the government safety interest here? It suggests that it's limited in time.
It's limited in time, but there are exceptions, and I think those exceptions are similar to what we have here based on what the reason was for the delay. And so if the reason, like in Menadonka, was that police observed this traffic violation, were sitting on it, this was very clear in the record. They had information that this individual had been seen near a motel before and stopped, had drugs on his person. They observed the traffic violation, observed him park in a motel, go in, come out, and then chose to stop him. And the court found that the reason that delay, 1 hour delay, was improper and rendered the pretextual stop illegal was because of the fact that police were attempting to gather more information. They were still conducting surveillance after this traffic violation.
But isn't that exactly what's happening here? I mean, I guess I'm wondering how this case is very different than that one, other than the delay is 23 hours longer.
So I don't think that's what's happening here. And I think that's because of, so again, there's an drug investigation going on separate and apart from this.
Right, and so when Feeney sees him the next day, he's surveilling him, just like they were surveilling the defendant in Mendanka.
But so Piraway, who observed the traffic violation, loses sight of him, does not continue surveillance on him, and stops him at the next available time that he's able to. So I think that's the distinguishing factor.
Is the record silent as to whether or not Feeney knew about the traffic violation?
There's nothing in the record about whether or not he knew about it. So I don't think we should.
Would that make a difference?
What's that?
Would that make a difference
If he knew about it, I think it would probably make a difference.
if he didn't know about it?
My reading of the record is he doesn't know about it.
Well, I asked you if it was silent. You said it was. So,
There is, but I don't think we can read into the record that he does know, where there's nothing in the record to suggest that he does know, I guess is my.
How does that cut for you? Because if it's a serious traffic violation and Feeney and Piraway are working together on the drug investigation, right? Maybe you would think he'd say, oh, I just saw him do a serious traffic thing too.
This is anti-collective knowledge.
Yeah.
Well, so I think Privet says that they have to be working together at the exact working together in the same investigation, which they are in terms of the drug investigation. But again, I think the traffic violation is separate, and there's nothing in the record to suggest that he had told him about it or that they were working together to effectuate.
It would have been your burden to establish that he didn't know, correct?
To establish that he didn't know. It's the Commonwealth's burden at the hearing, but where there's no testimony that he knew, I think, and the judge had all of this.
There's no testimony that he didn't know either.
There's no testimony that he didn't.
So it doesn't, if you have the burden to establish the point, then doesn't that leave you in a tight spot?
Certainly it would have been helpful if we had more testimony, if the record, again, had more not only about this, but about the reasons for the delay in the stop. But I think that the judge was entitled, based on the record and the testimony, to find that the reason was it wasn't safe, and that this was Officer Pirouet's traffic stop, and they didn't share collective knowledge, because there's nothing to suggest that they were working on this traffic stop investigation together, although there was this ongoing drug investigation.
Can I get you to address the second issue? So we got a busy street. They putter along for another, how long? 300, I can't remember. Is it
A block, yeah.
And turn off to the side street? Really? You know.
So I think again, here, the length of how long it took him to pull over is relevant, but not the only deciding factor. If you look at the testimony at the hearing, not only did he fail to stop for a distance of 1 block, but he attempted to continue driving and turn onto another street. Now, I disagree.
Was there somewhere he could have gone beside? I mean, where was he to stop on? I know your view is he should have stopped on the busy street, but that would have, again, created the traffic snarl that
It inevitably did happen in the end. But I would just say that and again, I understand it's the Commonwealth's burden, but the judge disagreed with the prosecutor's argument that he could have pulled over in an open space. There was no evidence of whether there was open spaces at that time, but he didn't explicitly find that there were no open spaces or nowhere to pull over.
But finding this to be, and again, you know, at least what this opens up is, you know, anytime you don't stop immediately, the cops can exit you and pat frisk you. Is that? That's troubling, right? And I feel like we're dramatically expanding what we can do for pretextual stops too, based on your interpretation. So go ahead.
I don't think so, Your Honor. And I think maybe the defendant and I disagree about what the facts were at the hearing and how that, whether or not.
Well, I mean, the facts were, I think, and you correct me if I'm wrong, stops or drives a block, slows down, like at a crawl, basically, and then tries to turn left, but doesn't accomplish that mission.
Mm-hmm. And I think
there's a rejection of the prosecutor's argument that there may have been spots to pull over on the right.
There's nothing.
Nowhere to pull over on the right. Next block down is a left turn, and he tries to turn left. I mean, that then anybody gets arrested for that?
And frisked?
So I think the testimony is what Your Honor said, but the officer's exact words were, first of all, there's a vehicle behind him with lights and sirens on, right? The testimony is it's right behind the vehicle. He attempted to continue driving and turn onto another street. He stopped only when the flow of traffic prevented him from turning. And at that point, police got out of the vehicle to stop him. the officer says, when it became apparent that the marked vehicle was behind defendant's vehicle, he attempted to make a left onto Bennett Street. To make a 90-degree angle turn, all of the vehicles in the oncoming traffic lane stopped. He wasn't able to make this turn. I think that testimony makes it more than just he was pulling over, he was turning at the next available street. And I also would remind the court that I think the way the defendant frames this issue is almost that it's a sufficiency issue after trial. This is a probable cause standard, which is obviously different than beyond a reasonable doubt. And I think that there is enough here. I don't think that this renders any person who is searching for a place to slow down safely, to pull over.
Hold on, but the probable cause, they frisk him. They can frisk him based on probable cause, or don't they have to?
Well, it's an arrestable offense, so yes. Yes.
So that saved him, right? I mean, that saved the whole thing, because had he pulled over in the middle of the street, there would have been no reason to make the exit order.
Yes, I think if this weren't a failure to stop, there would have been no reason to make the exit order.
Assuming it was a failure to stop was the reason that.
Yes, unless something else happened. Yes, I agree with that, Your Honor. If there are no further questions, Commonwealth rests on its brief. Thank you.
SJC 13797, Courtney Giraldi et al. Versus Roberta Orsi et al.
Okay, Attorney McCullough, whenever you're ready.
Good morning. May it please the court. My name is Scott McCullough. With me is co-counsel Paul Revere. Plaintiffs who could make it because of their condition or the weather are also in attendance. My sister and industry amici make this out as a wireless case with a health angle. We submit they are wrong. This is a public health matter where a local board was trying to enforce state law mandate when it found a situation that was injurious to public health, inhabitants, and estates. Chapter 111, sections 122, 143, and other provisions in state law. It happened to involve a wireless company. The question here is whether a state law board trying to comply with the state law duty to investigate and eliminate public health threats that it finds are occurring is precluded from doing so because of federal law.
I don't know if that's exactly the question, at least in my view. In my view, the question is whether the board could rescind its show cause order, correct? Because that's the only thing that's on appeal here.
Procedurally, what happened was they entered the show cause order.
Yes.
And then after they were denied the ability to defend that order in federal court, they rescinded it.
Right. So the question here, and that's the order that's on appeal, is the rescission order.
It is. That is the one we challenge under church law.
Correct me if I'm wrong, but don't we review that to determine whether the board acted arbitrarily or capriciously in rescinding its previous order?
I believe the standard of review is whether it was in compliance with law, arbitrary, capricious. And here, remember, we do have a state law mandate to eliminate public health threats. It had found there was a public health threat.
Well, it might be arbitrary and capricious if the rescission order violated the law. I mean, that might be, but I thought the standard of review is arbitrariness or capriciousness.
But there is also the legal angle. They had a duty to eliminate this threat that they found. And even when they were rescinding the order, they reaffirmed the belief that it was a public health threat.
It seems to me that the question is whether the board acted arbitrarily and capriciously when it determined, based on preemption grounds, that it needed to rescind its order. Because it doesn't look like they rescinded their order because they disagreed with the public health aspect. It looks as though they rescinded their order purely based on their understanding of preemption.
I would disagree with that, Your Honor.
You think they rethought the health?
No.
No.
No, what I think happened was they truly believed in what they were finding in the show cause order. And they only rescinded it because they were denied a defense. They could not have counsel before the federal court. And in the face of this situation, they decided to rescind the order. Every single one of the board members, when they took the rescission vote, reaffirmed their belief.
So that's even a harder case for you because what you're challenging is the a decision on what resources to allocate to what. You know, like we're just not going to we're not going to pay for counsel. And so the decision of the board is really, we're not going to do this on our own dime. And we don't have dollars from the city to help us.
They get their budget from the city. And there was not money in their fund to do this on their own, but they could not do this.
So your argument is that it's arbitrary and capricious to make this resource allocation decision.
I would contend that it is contrary to law to fail to act to remove a public health threat that you have found to exist.
When you don't have the funds to do it.
Well, enforcement of the order is one thing. And they were not trying at the time to enforce the order. The show cause order was, Verizon, please come and talk to us. We want to try to work together to eliminate this threat. There are things that could be done to reduce the health threat.
See, I don't know if that argument really helps you either, because then it's not even a conclusion that the order is preempted by federal law. We are using this as a bargaining power in order to bring Verizon to the table. And we're determining based on a lack of resources that that's just no longer worth our time.
They are
Properly
precluded
phrased.
by the municipal charter from hiring their own counsel. That, I guess, implicitly includes spending money for their own counsel.
I would think so.
So they were denied the ability to do what they want to do. They wanted to do this, but because they could not have counsel, they had no choice but to issue the rescission.
So the
issue here is whether state law commanded them to continue to try to enforce state law however they could.
It sounds like the issue is whether the board acted arbitrarily and capriciously in rescinding its order because it had to stay within the confines of the town charter.
Well, again, we are not faulting the board's actions.
Well, you are faulting.
But what we are saying is that the board was coerced into doing what it had to do. And I guess you could say that is arbitrary and capricious. If you look over in the federal administrative law context, there's a whole line of cases about outside political interference with adjudicatory action. And it does look at it sometimes through the lens of arbitrary and capricious. But really, it is whether the action itself was based on the record and compliant with law.
Almost none of this is brief. Can we talk a little bit about what you argued, which is that it's not preempted?
Yes.
Okay, so I read some of these cases. What's the best case for you that says it's not preempted? Because they're going to go stand up and cite about 30 cases where something very similar to this is preempted. So the only case you cite in your brief is a case involving the federal agency. It's not even a state agency case. So what's the best authority for you in a similar context that says this is not preempted?
I would start with this court's decision in Little.
Blue is not one of these cases, right? You're talking about a general.
It is not a wireless case. Well,
this is, wireless is an area that the feds have a lot of say in. So again, this is a kind of issue that comes up around the country. Give me one case that I can look at that comes out your way.
the first thing that I would suggest is you have to understand the lens through which to look at it, especially
I understand the lens.
when we are dealing with conflict.
I just would like a case, because it would really be helpful if I have a case that does what you want us to do.
On wireless?
Yeah.
Are you speaking to express preemption or
Any
conflict?
kind of case that allows a local agency to do what you want to do here? Because I have a bunch of sites going the other way, but nothing your way.
I would cite to the Federal Communications Commission itself.
That's a case involving the Federal Communication Commission's actions itself. It's not a case in which a local agency was allowed to do what you say should be done here.
This is a case of first impression in the country.
It can't be a case in around the country.
I'm not aware of any other health board that was called upon to investigate this.
So when she stands up, she's not going to have any cases like this where preemption was found? She's going to come up, I think, and say the opposite.
Yes, many of them will be either in a tort case context under conflict preemption, or they will be zoning cases where certainly the statute does apply, 332C7B, IB. But our contention under express preemption is that that whole piece of it does not apply because it is limited to zoning. Now, I do want to return to the FCC if I could, because it's really important to understand. The commission has ruled that generally applicable health and safety laws are not preempted.
I thought they say the opposite, that the locals have an ability to cite these telecommunication towers. Locals have an ability to say, this part of the town is not subject to that. What they can't do is use the health consequences of a radio tower to limit what the radio tower can do once it's been sited. That's why I'm asking you for a case in which someone says you can do that.
If you are speaking in the context of express preemption, then we have to work through the statute, first of all, to figure out whether it applies at all. And remember, this is a clause to a subparagraph to a paragraph that has in the caption of it, preservation of local zoning authority. So that is a zoning statute. The whole paragraph itself simply does not work when you have a situation like a health board. The second thing here is, as we have suggested below, my sister and the industry have yet to explain or accept that these networks themselves, they are a patchwork. And there are any number of ways to adjust this, many of which might not involve changing the level of energy that is being projected by this. They could just change the angle of the antenna, for example, so that it goes higher above the roofs in Shacktown to reach out to the Berkshires where this was designed to serve. These cell towers are indeed patchworks.
Counsel, I'm getting confused because it seems like you're jumping all over the place from where we were in the briefing. You keep talking about express preemption. How does this fit into Judge Flannery's decision? Because Judge Flannery's decision wasn't grounded in express preemption.
That is correct.
It was in conflict preemption.
That is correct.
So you're all over the place in what these issues are. So explain to me how Judge Flannery got this wrong under conflict preemption, where if you can't get in the way of where you have some say in where the towers can go. But if you're going to then do something that's going to affect the operation of it, that you can't do this. And Judge Flannery was pretty deliberate in walking this through and saying, okay, operationally, this was what this would do, and they found that they can't do this under preemption, and that's why they pulled back on the board pulled back on what they did. And why was that wrong?
First of all, I need to take issue with the proposition that the board found that they couldn't do it because of preemption. They never made that finding.
Well, they rescinded, whatever it is that you characterize it, you can characterize it any way you want, but they rescinded it.
They did. Conflict preemption is this particular variant of conflict preemption, because impossibility preemption was never raised. This is called purposes and objectives preemption. And so the question before the Superior Court was whether the board show cause order, if it had remained in effect, would substantially interfere with the purposes and objectives of the FCC rules.
Sure, it would have, because it would have shut it down. It would have shut it down.
Not necessarily.
Well, okay, if I'm going procedurally with what happened here, I know you're playing games with the labeling here, but they issued the order to show cause. Verizon didn't come to the table, and it in effect became a cease and desist order. You can't argue with that, okay?
I do take some issue with the general proposition that
the letter itself, the letter itself said that.
What the letter said was, we find that you are violating the health code, and we want you to come in to find a way to no longer do that.
Why don't you quote the letter itself? What happens after the 7 days when Verizon doesn't come to the table? What happens?
The ordering provisions on page 14 in the record, A at 79, said in paragraph 8 that Verizon should come in and request a hearing. And if it did not, then it should abate and eliminate all activities and operations leading to the present and ongoing nuisance and violation.
So it shuts it down?
Not necessarily. Verizon could have solved this by doing something to the tower that would have quit making people sick. And that did not necessarily involve shutting it down.
If Verizon did none of those things, they couldn't operate, right?
Verizon could have, for example, and this is laid out in the argument.
You're not answering any of our questions.
I apologize.
If Verizon didn't do any of that, the board said stop operating that tower.
Instead, stop violating the health laws.
Okay, well,
eliminate all operations leading to the present and ongoing nuisance and violations. That doesn't absolutely and clearly say turn off the tower.
Well, effectually what they wanted was for them to reduce the amount of emissions coming out of the tower. And that's where it gets to the heart of the conflict preemption problem here that was identified, right? Because you would concede that there is a purpose of the statute is to preempt a patchwork of emission standards across the country, would you not?
The board did dedicate a lot of discussion in the first part of the order to talking about RF emissions. They did. But ultimately what their goal was to stop the illness. And if Verizon had merely come and gotten past its argument that you are preempted, and two, this can't be hurting people, which the board found was not credible, then we would have had many opportunities to try to figure out a way to stop making people sick while still allowing Verizon to meet its service objectives. And I will tell you, there are many ways that this could be done. It was simply that we never got to that point. Now, patchwork. I cannot emphasize to you enough that these cellular networks are patchwork networks. Every single cell site is different. Some tall, some short.
Can I get you to focus on the law for a second?
Yes.
332C7B4. Doesn't that preclude what you're saying. You can't do anything to the extent that such facilities comply with the FCC's regulations concerning such admission. Don't you run smack into that?
I have two answers to that.
Go ahead.
First of all, again, I contend C7 and C7b little I does not apply to this context. It's about zoning. But second, the answer is actually not. The FCC guidelines set out a maximum permitted exposure level beyond which they are not supposed to go. But also, there is a federal statutory requirement to operate at the minimum power necessary. So the statute actually says you've got to, at all times, operate with the lowest power necessary, but you cannot exceed this amount. Now, what we think is entirely possible is that we can find a way so that they can still provide service, emit enough power necessary to effect the desired communications. But it might, perhaps, as one alternative, be to reduce the power level from what they have now. Now, the commission does say, the rules do say, you have permission to operate up to this amount when necessary to effect the desired communication. But the federal rule is also that you only do that when it is necessary to effect the desired communication. And the real rule
What is the evidence in the record that Verizon is violating this range that you're talking about?
There was some evidence before the health board on their power emissions, and it did generally show that they were well within, admittedly, the maximum permitted exposure levels. But there was no evidence, Verizon certainly didn't put any in, showing what would be the minimum power necessary to effect communications.
And you didn't put any in?
We did not.
Okay.
In the footnote in your complaint, you say that as of the date of the complaint, there was no written order reflecting the rescission.
That's correct.
And the boards had not approved its minutes of the meeting at which they decided to rescind their order. If any of that is now available, I would appreciate it if you would file that with the court. I didn't see it in the record, and maybe I'm missing the rescission order in the record, but I couldn't find the rescission in the order or the board's minutes that would explain why it rescinded its order. Those seem to me to be important pieces of the record that should be supplied.
It's been a while since I've checked, to be candid, but last time I did check, it had yet to be memorialized in minutes. We do have the video in the administrative record that we supplied to the Superior Court of the vote.
Okay, well, it seems important to this case that we understand the reasons the board gave for its decision.
We'll be happy to supplement and get that before you.
Thank you.
Thank you very much. We ask that you reverse the Superior Court and send it back and let the court finish resolving the matter. Thank you.
Attorney Lord.
Good morning, and may it please the court. The board's position is that the Superior Court judgment was well-founded in the law and should be affirmed. This case presents a narrow issue. It's the extent to which the TCA preempts local and state governments and their instrumentalities like the Board of Health, the authority to make laws or otherwise regulate the telecommunications industry, including RF emissions that fall within FCC standards. If I may, I'd like to give a little brief case background because it's a convoluted history.
Before you do that, I just want to read the relevant language we're looking at is this regulatory provision that says expressly, no state or local government or instrumentality may regulate the placement, construction, and modification of personal wireless service facilities on the basis of the environmental effects of radio frequency emissions to the extent that such facilities comply with the Commission's regulations concerning such emissions, right? So it's,
yes, Your Honor.
It's right there in black and white.
I agree with you, Your Honor. Although the Superior Court did found its decision on conflict preemption, we do believe that there is also express preemption. And as you know, on a de novo review, you can look at the record and rule any way you believe.
So as to that language, though, why is environmental effects? Why does that include the health issues that are at the center of this?
Sorry, Your Honor. It's explicitly included in the statute that environmental effects includes potential biological impacts and health impacts.
What statute?
I'm sorry, I don't have the citation, but it is within the TCA. I will find that site. But yes, the TCA specifically includes health impacts as one environmental effect. And then going back to Justice Kafker's question, the reason, although that's in a zoning subsection, I would argue that it is in a zoning subsection that carves out a very limited safe harbor for local and state governments to have authority. And in carving out that narrow safe harbor, they further limited it to say that you still can't make even zoning decisions based upon these limits. So if you aren't permitted to make a zoning decision based upon those limits, once the tower is sited and constructed and operational, it would be counterintuitive to then say that local boards of health or other local instrumentalities or state government could then limit your operations when you're complying with.
You do have, the local government has the ability to deal with modifications of, I don't know what that means exactly. Is that physical modifications? Is that defined in the regs of the state?
I did not see it defined. Modification can mean many things. It can mean physical modifications. It can mean modifications of RF emissions, right? So that is unclear. But in any event, those modifications aren't permitted if it's based upon RF emissions and perceived environmental impacts, which includes, again, health impacts. So, to say that you can build it, but then you can't turn it on after going through zoning, siting, licensing, construction costs, that seems to be a direct conflict with the goals and purposes of the TCA, which is to create a national uniform standard, because we have 351 municipalities in the Commonwealth alone. You can imagine a scenario granted to the extreme, where every single municipality creates differing standards, at which point the services that are there are going to be interrupted. You're going to lose further investment in technological rollouts in those areas.
So back to Justice Kafker's question, and I'm sorry, Justice Kafker, it sounds like maybe that's where you were going. I thought your position initially was the Superior Court judge could have grounded this in express preemption. But now you're talking about what the Superior Court judge actually did do, which was the obstacle conflict preemption.
Correct, Your Honor. I do agree that the obstacle preemption is exceedingly clear in this case. And so I do think it's an easier ground. I do believe that zoning section shows the limitations of that safe harbor and therefore could form the basis for express preemption. But I do agree that Judge Flannery's decision as written was strong and that conflict preemption is the easiest path to take.
So there's serious health allegations here.
Yes, Your Honor.
And does the FTC have the ability to, because the FTC can come in and play with they can play with the waves, right?
The FCC?
FTC.
Oh, I'm not sure, Your Honor.
What's the relevant federal agency?
FCC.
FCC. Can the FCC come in and deal with the health issues? They have the power to do what? I'm just trying to understand if this is a case where we're fighting the wrong battle on the wrong battlefield. Because it's troubling if people are getting sick that there's no remedy. But if there's an alternative federal remedy, it's a lot less troubling. So
yes, Your Honor. So there's a couple of options, right? So option one is, of course, you can work with your federal legislators and try to make a change.
Good luck on that.
Good luck. I agree. It's an option. I didn't say it was a pretty one. It does exist.
I'm just trying to understand, as a lawyer,
yes,
if I'm dealing with health effects, do I have a federal avenue trying to deal with the FCC to address these health problems?
You do, Your Honor. And in fact,
and how do you do that?
So under the rulemaking, so FCC actually engaged in further rulemaking in 2019, re-examining these 1996 standards. And in fact, a case, Environmental Health Trust, argued by my brother at the bench here, the DC Circuit didn't say that the levels were improper, but said we want more support from the FCC and remanded it back to the FCC for additional rulemaking. I am aware that the Environmental Health Trust case, there's been a fairly recent filing in that, seeking to have the DC Circuit push the FCC along on that front. You can also make FCC complaints. And I believe I have one more.
Can you make complaints based on the environmental effects of the wave? Again, I defer to my colleague, the MIT engineer, on what's happening with the radio wavelengths. But go ahead.
You can. So we've got the DC Circuit. So again, you can file actions there. There is an action pending where this may, in fact, change some of those standards. We don't know at this point in time.
Is that a national case? But can you get to a local micro level with the FCC? Is there some regulations or statutes that allow you to do that?
On that, I don't know. I would presume that the DC Circuit Court would be the appropriate venue for anything involving that agency, but I am not certain of that at all. But I believe that because it's located in DC, it's a federal agency in DC, that the DC Circuit would be the appropriate court to take any such actions based on environmental impacts.
Am I correct that the record does not include the precision decision of the board?
As you ask, I could not point directly to it. I've read obviously a lot of things. I do know that there's minutes from the executive, there was minutes from that meeting where they talked about why they did it.
All right, so that seems to me important to nail down because in the complaint, this was a motion to dismiss, so we're basically going to review that based on the allegations in the complaint. The factual allegations in the complaint concerning the rescission order are that the board was coerced in rescinding its order. It didn't say anything about preemption. It said that it was coerced because they were deprived of counsel, not given funds, et cetera, et cetera. And we would review that decision based on those allegations in the complaint ordinarily. Preemption seems to have been introduced somewhere along the line, and I'm not sure if it was actually a basis for the board's decision. In your brief, you actually mention it as being the basis in the conclusion, but in the body of your brief, you accept the contention that the board made the decision to rescind its order based on practical considerations. I'm really confused because I think that I'm not sure what the issue is, the legal issue in this case, given the state of the record. So can you help me resolve this?
Yes.
In some way?
Yes, Your Honor. I would point out first that any and all aspects of the complaint that related to coercion or undue influence, those were all dismissed. They were not appealed. So those counts have gone away. They do not exist.
I'm talking about the factual allegations, not the count.
As it relates to the decision to rescind, that comes down, practical considerations. When I use that term, I was relating to the fact that it was based upon a review of the law relative to preemption. It was based upon the costs and the risks of litigation. In the face of that, that was the decision. So that's the
So where do we see that in the record?
Yes,
that was the reasoning of the board.
As my brother mentioned, we will supplement with that piece. We do have those minutes, and we can make sure that they get to this court. And I believe you have the video, and we will make sure you have that as well.
So in the abstract, assuming the board made its rescission decision on a grounds other than preemption, why would we be considering preemption in this case?
But that was the practical consideration, Your Honor, because the costs of litigation, the likelihood of losing after spending taxpayers' money based upon the current state of the law, which says conflict preemption prevents the board from taking this action. Rescinding the order without prejudice was the most judicious use of our resources, and it was based upon the fact that preemption was going to defeat us.
So if the board were wrong on the issue of preemption, what's the standard? Does the board, in other words, I'm not sure that the standard of review is that if the board got that legal issue wrong, we would reverse the rescission order.
I agree.
Right? Because I'm not sure that the standard is that they have to get the law 100% correct.
Right, you're right.
All right, so what is the standard?
So we believe the standard is arbitrary and capricious. And when you have a well-founded, reasoned belief, and then you make your decision accordingly, the decision to rescind that order, therefore, is not arbitrary and capricious. It's well-founded.
So can you address the argument raised, I think, in Verizon's brief that this whole action should be dismissed because a certiorari and a DJ is just not available in this context?
You know, it's an interesting argument. This case came before the Superior Court under Standing Order 1-96, which specifically allows for review of the decisions. The argument we would make is that, well, we're here, so we're reviewing it. But the second part I would say is that in terms of if you view it as a cert action, you know, the burden is on them to prove an error of law because they brought the action. And I don't think they've carried that burden. In terms of a declaratory judgment, you know, it's applying the law at hand to the basic facts at hand. And I think that, you know, there's clearly a controversy between the parties, not necessarily in the law, and that they want clarification. So I think in either case, we prevail. Judge Flannery's decision was well-founded. The board's decision in rescinding the order was reasoned and based on law. As I was going back to my other argument, I'm sorry. We note that in terms of telecommunications and radio, the one thing I do want to point out is we refer to the Telecommunications Act of 1996 a lot, but the originating authority for the FCC is actually much older. It's the Communications Act of 1934. And under the 1934 Act, they were given broad authority to craft these regulations. In fact, they had started rulemaking relative to RF emissions before the Telecommunications Act of 1996. And in the Telecommunications Act of 1996 is where Congress specifically instructed them to create these standards under their rulemaking authority. So again, this was something where Congress has explicitly stated that they want the FCC to regulate this particular area. And again, you know, we go back to the proposition that to hold preemption does not apply in this case and does not apply to cases where people are complaining of health impacts due to RF emissions opens the floodgates. And, you know, as I said, 351 municipalities in Massachusetts alone, you extrapolate that to New England, you extrapolate that to the United States, and it very quickly becomes untenable amount of standards that companies and communities would have to.
Can I ask you to address this maximum minimum argument made by your opposing counsel?
The floor, not a ceiling. We agree that the statute sets a ceiling, not a floor, but it is within Verizon's purview and wireless company's purview to set the limits that are necessary to reach to the next tower or to fix the coverage gap that exists. With our towers operating completely within limits, in fact, well within limits, and if we start changing the limits on individual towers, you know, we keep talking about this one tower, but if you change those RF emission limits on that one tower, you're going to change the range that signal goes. And so you're going to start creating coverage gaps, even though there's sufficient towers in place, those gaps would not exist. So it's, you know, it's not the one tower, it's all of the towers. And again, that it could be set lower might not achieve the purposes of that particular tower in reaching to the next tower.
Thank you.
Thank you, Your Honor.
Court, all rise, please. section, please proceed.
SJC 13792, Commonwealth versus Stefano Nicholas Sarakis, and SJC 13796, Commonwealth versus Maurice M. Smith.
Okay, Attorney Lee.
Madam Chief Justice, and may it please the court. Special ADA Chi Chi Lee from Middlesex on behalf of the Commonwealth. With me is ADA David Yasnovsky. He's the attorney who crafted the argument below and argued one of the motions. This is a case about applying the plain meaning and a rule against superfluity to Section 10M to reflect the legislative intent. This court has an obligation to give the statute a reasonable construction. When this court's interpretation makes a word meaningless, this court fails to respect and fulfill legislative intent and breaks the separation of powers. Therefore, this court must give the phrase not less than 2.5 years in Section 10M the meaning. The appeals court earlier—
The meaning you suggest is that this not less than 10, or whatever the years is, not less than, what is it, 2.5? Not less than 2.5 is the minimum of the maximum. That's your interpretation of that language.
Yes, under the constraint of Rodriguez, that's the only way to give that 2.5 years a meaning. And that's what the appeals court held earlier this year in Da Silva. Although there's no amicus file any brief here, the appeals court upstairs reflect that idea for this court. What the appeals court did in Da Silva was Rodriguez did not touch on the maximum of the sentence. It responded to a reported question that 1 to 2.5 years is a legal sentence. Between the conflict between the first and the third sentencing provision, this court only held that the mandatory minimum is 1 year from Rodriguez. So the question now becomes, what do we do with the 2.5 years provision? If this court were to abide by the rule of lenity without giving any meaning to the first provision of not less than 2.5 years, this court will render a sentencing provision superfluous, which is what the Hines court did, and that's why this court rejected.
Isn't it not less than 2.5 years ambiguous? If you're saying one way to give it meaning is that it's the minimum of the maximum, and the other way to give it meaning, which is, I think under our majority decision in Rossetti, is that those kind of words mean the minimum term. Isn't it ambiguous? And then the rule of lenity would kick in the favor of the defendant.
No, Your Honor, because the only way to give meaning to the first sentence is to how much meaning we can give to that 2.5 years. Understand that not less than the phrase itself is controlled by Rossetti, which goes to the minimum of a sentence. However, if this court to create a minimum maximum after Rodriguez, that allows this court to give the other part of that phrase 2.5 years a meaning. If Rodriguez actually controls every sentence for Section 10M, then the legislation could have just said 1 to 10 years. That first sentence would not make any sense or any meaning if the sentence really is 1 to 10 years, and that's not what the legislation intended. So
Did the legislature amend 10M since our Rodriguez decision?
In 2020, no, Your Honors, but there was a revision to Section 10 in 2024 and 2025. That was response to the Bruin case.
Did they amend at that time anything with regard to this, what I would call ambiguous, not less than 2.5, a minimum of 1? Did they do anything about that language?
No, Your Honor. However, that legislative silence is not an approval. For example, if you
they let Rodriguez stand, which says 1 to 2.5 is a lawful sentence, correct?
Yes, that did not change the interpretation of this court.
They've passed on 10A, and they've passed on the Rodriguez interpretation.
However, this court, that's what happened in Rossetti. Rossetti was a case that overturned Hines' interpretation after 15 years. And in 2018, the legislature had a criminal justice reform that changed the landscape, the length of sentences. This court, however, still overturned Hines because it was an erroneous interpretation, and that's what happened here. Rodriguez was a wrong decision. It treated the third provision as a guidance for a judge to the sentencing range, what a judge can impose. But the word impose itself shows that it is about how the DOC or the administration or the government.
Was that argument raised to the court in its composition under Rodriguez in 2019?
No, and the Commonwealth—
That argument did not come up.
That's correct, Your
So
Honor.
this is a new argument you're saying that you're presenting for the first time for us to consider, and that Rodriguez did not have the opportunity to consider it.
Exactly. At the time, the Commonwealth should have been more helpful to the court, which is part of the reason why the Rodriguez court was wrong. And this is why this...
Excuse me, can we just, what exactly are you saying that the Commonwealth did not argue in Rodriguez? Because I actually read the Commonwealth's brief in Rodriguez, and the last 2 pages or maybe page of the brief makes an argument that reduced, I think in that case, it was pretty fine-grained arguments, and the defendant actually argued that reduce can't mean the DOC model because you can't get to a reduction to under 1 year from a 2.5-year sentence. And the Commonwealth responded to that by saying that actually the furlough provisions could. So wasn't exactly all of this before the court in Rodriguez?
Yes and no, I apologize for not being precise. That argument that the 1 year is not a mandatory minimum was raised, but the reasoning was not raised. So all the reasoning Commonwealth presented here in this case are new. That did not...
What is exactly new? Because it was debated by the parties in Rodriguez that reduced referred to actions DOC might take, was it not?
So in that case, the Commonwealth did not cite to Section 129C and D, which is about the administration of the sentence about...
By the DOC?
Sorry? By the DOC, yes, Your Honor.
Okay. So you're saying because the particular sections were not identified, although the issue was covered, this is now a new argument.
And there's more to that. For example, the Commonwealth at the time did not focus on the word impose on the 3rd provision. And that word impose, we've guided this court to the plain meaning of the 3rd provision. It's about how to administer a sentence after a sentence is imposed. And if you look at, there are other statutes.
What would be the limiting principle you're suggesting on our rule on stare decisis?
So this is not a case where the Commonwealth raised exactly the same argument. This is not a case...
But it has to be the same exact argument, not just one shade different.
Right, but even if it's the same, this court should not perpetuate judicial error. And in Rossetti, as Justice Wenham pointed out in your dissent, Rossetti overturned Hines based on the exact same argument that was raised 15 years ago to correct an error that reflects...
And the correction was that not less than shall mean a minimum term.
Yes, Your Honor.
And now you're saying not less than shall mean a minimum of the maximum term.
So there's really 2 points.
So really you're asking us to not overturn Rodriguez, but to revisit the clear language in Rossetti.
So if this court were to harmonize the first issue, which is what to do with the 1 to 2.5 years sentencing range after Rodriguez, the way is to treat this case as an exception, because the not less than language is a unique creature because of Rodriguez.
Didn't Rossetti say that 10M is just a different statute, and we have to take it out from the scheme because it's contradictory on its face?
Yes, Your Honor, and that's why this court rejected the defense argument with reliance on Rossetti. So the point really is if
Rodriguez.
Yes, Your Honor, and the point is...
So in terms of not necessarily, I guess if you're announcing that we should announce a new rule, is there any set of circumstances under 10M where it would be lawful to impose a maximum sentence below 2.5 years?
No. If this court were to overturn Rodriguez completely, the mandatory minimum should be 2.5 years. So a legal sentence has to be minimum of 2.5 years and the maximum not more than 10 years if this court were to overturn Rodriguez. And if this court look at chapter 269, section 50, 51, 53, and 26D, these statutes have the same minimum as the reduction sentence. If the reduction language truly means a mandatory minimum, why would the legislature repeat that same language in this many statutes?
So your position, we do away with Rodriguez in a proper statute is 2.5 to something to 10.
After Rodriguez,
with a minimum mandatory of 2.5.
If this court were overturn Rodriguez moving forward, yes, Your Honor.
Okay. What do we do with the 1 year language in Rodriguez in the statute?
Moving forward, if this court were overturn Rodriguez, that 1 year tells the administration you cannot reduce the sentence less than 1 year, whether the minimum or the maximum. And that's what.
But if 2.5 years is the mandatory minimum, how can anybody reduce it to 1 year? If it's a mandatory minimum, even DOC doesn't have that authority, does it?
No, Your Honor.
So what does the 1 year mean then?
Well, it could mean, for example, the FID card holders, they can be sentenced to any range to state prison. And if that sentence is less than, it's above 1 year, whether the minimum or maximum, that sentence can be reduced to less than, cannot be reduced less than 1 year. That will still apply. And that's another argument.
Wait, I'm sorry, can you say that argument again? Sorry.
Yes, Your Honor. So in your question, the interpretation will work. The 1 year reduction will apply to FID card holders because they can
but the second sentence then becomes a problem because the FID card holders are not subject to any minimum in the statute.
Yes, but point is, if
So you're
the judge,
resolving one ambiguity by bumping up into a direct express no minimums for FID holders.
no, Your Honor, my example is when a defendant is sentenced to state prison, which is possible under the statute. If that happens, for example, if the judge sentenced a defendant who has the FID card 6 months to 1 year and a half, that maximum cannot be reduced to 1 year. That person has to serve 1 year before he can be legally discharged from the DOC custody. And that's one.
But you're saying that the third sentence, which sets forth a minimum of 1 year, applies to those FID holders, which the second sentence says they are not subject to any minimum.
Yes, but until they can be sentenced to a certain range. So the person has to serve 1 year. That apply to both minimum and maximum of a sentence
Okay,
imposed.
stop there. You said he has to serve 1 year.
Yes, Your Honor.
Isn't that a minimum mandatory?
No, a mandatory minimum is a range for the judge to impose. What the defendant actually served is a different question for the DOC administration. And then I think that's what went wrong in Rodriguez, because the focus of mandatory minimum was all focused on the judge's range. However, the third provision is about the DOC's power.
I think you're getting really greedy. You might win on issue number 1, but issue number 2 seems like a non-starter for you.
The problem with the second issue is this court only believed that it was a standalone provision, but that's not. That provision will apply to Section 7, which is what LIFA was about, or the four statutes that I mentioned earlier. And if you look at Chapter 265, Section 15A and B, 15A is ABW over 16 subsequent. That case has a minimum of 2 years and a reduction of 2 years. And 15B has a reduction of 1 year, minimum of 2. That shows there's a difference between how much the legislature really want a defendant to serve when there's an ABDW 2 and 2 and ADDW 2 and 1. The legislature has shown its intent of what the third provision really is about in other statutes. And if you look at 265, Section 50, 51, 53, and 26D, as I mentioned earlier, that's a case where they have the same range. That would make the third provision completely meaningless if the minimum is already 1 year. And if you look at 15A and 50B, or 18 and 19 of Chapter 65, those statutes also had an inserted language of until X number of years of state sentence have been served. The legislature have been other statutes tell this court what the third provision reduction is really about. It's about a defendant has to serve that time before the sentence.
Well, don't we usually, to the contrary, if the legislature uses language in one place but then doesn't use it in this statute, don't we usually attribute some significance? They could have written a statute here saying the defendant must serve such and such, et cetera, but they didn't. They said shall not be reduced.
I agree with that. However, if you look at the totality of the third provision, the only difference is really that phrase until an X number of sentence is served. And there's no other way to really treat the third provision, because the conclusion Rodriguez court did was, we don't know what to do with first and the third provision, so the rule of lenity applies. However, if you look at all other statutes, you look at the administration statutes from the DOC, it tells this court the third provision is about how the DOC should administer a sentence. No further questions. I'll rest my brief.
Thank you. Okay, Attorney St. Lawrence.
Good morning. May it please the court. Timothy St. Lawrence for Stefano Sikarakis, who's watching via the live stream. I have a lot to say about the statute, but if I could just briefly make one important point, and that's that even if this court decides that the NM sentences in this case were illegal, the court should nonetheless affirm those sentences under Commonwealth versus Ellsworth, interests of justice and finality, where Mr. Sikarakis has fully served those sentences, and where the judge at the plea colloquy offered to defer sentencing to allow the Commonwealth to litigate this before sentencing. So for those reasons, we would ask for that relief. Turning to the statute itself, and the first question, the Commonwealth says that there's no other way to give the 2.5 meaning. We would suggest that there is another way to give it meaning, and that's that it's not a minimum maximum. It can be viewed as a maximum minimum. And we actually think that might be what the court said in Rodriguez with its language about the lower end of the sentencing range is 1 to 2.5. We think that actually makes more sense.
Do you think it's odd that the legislature would put two different minimum mandatories? I mean, you have the not less than, which is your argument, Rossetti, that it means if you sentence, which Rossetti says, not less than means you don't have to send someone to jail. But if you do, you have to sentence to this. So here you're attributing that language, but then in two sentences later, the legislature sets the minimum mandatory at 1 year. How does that live in the same universe?
Right, and I think that's the confusion that courts have been identifying with this statute.
Unless you call it not less than in this circumstance means it's the upper end.
Right, because the court in Rodriguez said we can't kind of make sense of these two minimum terms that we're given here. And so the rule of lenity is we're gonna go with the lower end.
So it's gonna be 1 to 2.5 is the sentence. Really what the legislature was doing was imposing a split sentence. It's 1 year to serve, right?
Well, they couldn't, yeah, but.
They couldn't, but they did.
Right. So along the line, something got lost in translation there. But.
Can you explain to me where you started, which was that the 2.5 years could reasonably be read as a maximum of the minimum?
Right. That a judge can set that minimum term anywhere from 1 year to 2.5 years. And that would be
that I understand, but why?
Okay. Well, the reason we say that is if this court says, we have to give meaning to this, which I don't think you do, but
usually we try.
Yes, but I guess to put it this way is, it's not clear that this is as the Commonwealth says, a minimum maximum. It could very easily be a maximum minimum because it would keep it as a minimum term. It wouldn't convert it now to the other side of the ledger, making it a sort of maximum term. So it would do less violence, I think, to the language of not less than. There's precedent where the legislature has created so-called maximum minimums, and that's 279, Section 24. It's cited in my brief. And for certain certain life sentences, the legislature has said, you're not setting a minimum above a certain number. So say 20 or 30. There's no precedent that I found for a so-called minimum maximum. The only time I saw that was Hines, and that's been overruled. And we think, it would obviously comply with the rule of lenity because it would be giving the defendant the benefit of the doubt of what this 2.5 means. And then lastly, I think it strikes a better balance between sentences for FID card holders versus non-FID card holders, because under the Commonwealth's theory, two, similarly situated defendants, one with an FID, one without, one is going to be entitled to not only probation, but will be entitled to a 1-year sentence where they can receive good time. But this other person, similarly situated, let's say the same conduct, is now facing a sentence 2.5 times greater. And for the simple act of having an FID card, which...
But that's what the legislature gave us.
No, they certainly should have a benefit, and it should be the option of probation.
Well, I could turn around and say, why does somebody with 4 AR-15s have to do a year, and somebody who has a 10A, who just happens to have a 22 under receipt that was given by the 25-year-old, has to do 18 months? That doesn't seem to make a heck of a whole lot of sense either.
Right, but the judge certainly has discretion to give more than a year. A judge can give up to 10 years, and we know that's the action. The 10 years is the sentence.
Well, let me just go back to this for a second, because although you say that there may be some talk that that this doesn't fit within Rossetti, Rossetti really talked about that. Particularly when in the not less than, that we're talking about a minimum term for an indeterminate sentence. And so why doesn't that necessarily and comfortably fit into the analysis of De Silva that the appeals court got this right? That it harmonizes with Rossetti, that if we're going to say under Rodriguez that you have to give at least a year, but the high end of the minimum term, which is the only thing that was before the court in Rodriguez, is 2.5. So that's fixed. That's the range that you can sentence under the low end, and that in keeping with what we said in Rossetti on the low end, and what we said on Rodriguez on the low end, and what we said in Rossetti on not less than, that the minimum mandatory high end is 2.5 to 10. Why doesn't that make sense to kind of harmonize all Rossetti, Rodriguez, and even though it's not authority, but persuasive authority, De Silva?
I think it asks the 2.5, the 2.5 years to do too much work.
Well, in Judge Ham's interpretation, the 2.5 does no work.
Right, which I think there is a reasonable interpretation of Rodriguez, that you chose between two minimums, and to some extent that 2.5 is a remnant of poor draftsmanship. And
or it could be the line of demarcation, right? 1 to 2.5 fixes the range that the judge has on the low end, and 2.5 to 10 fixes the range that the judge has on the high end.
Right. I just don't think there's enough to say that that's what the legislature intended when it made this statute.
Can I ask you a question about the scope of our holding in Rodriguez? It seems to me very clear from that decision that the court was faced with a really challenging statute and was trying to give effect to all parts of it. It had in front of it a sentence that was 1 to 2.5 years, and so insofar as the first sentence imposes a minimum maximum, it met that criterion. Isn't it necessary to the court's holding in terms of construing the statute as a whole that the 2.5 to 10 does do work and does impose a minimum maximum? Because otherwise, the court in Rodriguez was purporting to give meaning to all of the language of the statute, but actually was just utterly disregarding the entire first sentence.
Well, I think it qualified, and it was doing it the best job it could to give meaning to everything in the statute. I think it was quite the job with this statute. But I think the meaning that they gave it was the maximum minimum, that the lower end of the sentencing range, meaning the minimum term, the parole eligibility term, can be anywhere from 1 to 2.5. And that's how we give it meaning.
I realize that that was the question that was presented was about the lower bound, but the court was trying to give meaning to all of the sentences of the statute, right? And so what meaning did the first sentence have in Rodriguez if it didn't do anything?
The first sentence meaning the
2.5 to 10.
2.5. I think they determined the meaning of that not less than 2.5 was that it's a minimum term, and therefore we're gonna the best meaning we can give it, you know, consistent with rule of lenity and all these competing interests, is that that's the highest minimum sentence that could be given. It's not perfect, but it's an imperfect statute.
What do you do with the language that says in the second sentence that any person with an FID card shall not be subject to any mandatory minimum sentence imposed by this paragraph? Because you're essentially saying, well, 2.5 years would become a mandatory minimum at the upper range of what could be imposed as the minimum.
No, it wouldn't be a mandatory minimum. It would be a discretionary minimum. It would be the maximum that a judge could give as a minimum term.
How do you square that with the language that that a person holding an FID card won't be subject to any mandatory minimum? Because if you're going to use imposed by the paragraph, if you're going to use the 2.5 as a minimum, doesn't it run afoul of that part of it?
I think that they're treated differently. So the non-FID card holder could get 2.5, but it wouldn't be in any way mandated that they get. They could get 1 to 1 in a day, and they would actually serve. The FID card holder would serve less potentially, because they're not subject to the mandatory minimum DOC restrictions.
So you would say that the 2.5 gets transformed from a mandatory minimum to a discretionary minimum.
The 2.5 was never a mandatory minimum. It was a minimum term, and it gets it stays a minimum term, but it becomes the maximum minimum term. Is our position, and that keeps it on that side of the ledger.
Okay, thank you.
Thank you.
Attorney Durden.
May it please the court. Keith Durden, I represent Mr. Maurice Smith in this matter. And likewise with Mr. Smith, I would ask the court, in deciding this case, regardless of which way it goes, either in favor of the defendant or the Commonwealth, to take in consideration that the plea deal that was entered into was negotiated, and there is in the interest of justice, I would ask the court that it give some finality to that sentence and allow Mr.
Has Mr. Smith served the sentence?
He's practically served the sentence. He's almost done.
Okay.
With respect to the statute 26910M, it's our position that, as the court noted in Rodriguez, it's a very imperfect
It's imperfect, but if we in Rodriguez intended to create this new range of 1 to 2.5 years, why didn't we just say so? We didn't say that.
I think that with the court, well, in the language in Rodriguez, it can be interpreted in such a way where that's essentially what the court did say. And that's
well, then what does that do? What does that do to the 10 years?
Well, I believe there's a bifurcation between the lower end of the sentence and the higher end of the sentence. And what we argue is that the lower end there of the sentence is where the mandatory or the minimum sentence should be served, whereas the higher range of the sentence or the higher number is one where the court has a great deal of discretion. So, theoretically, a judge could sentence someone to 1 year at least 1 year in the minimum, but the higher sentence could impose a higher sentence, 3 years, 4 years.
Well, it seemed to suggest that, okay, so in your view, this was just a sentencing decision that Judge Hahn made, that the high end was going to be a year and a day.
Yes, correct, Your Honor.
Okay. But I guess I go back to the question I asked your brother. Well, what does that do to the 2.5 years? Doesn't that render that number just superfluous?
I think certainly it can render the 2.5 years superfluous, and we accept that. However, I think that given the statute being written the way it was written, there's a great deal of difficulty in interpreting it.
So you would disagree with counsel that we can give 2.5 years, meaning by keeping it on the minimum end of the ledger and just saying it's the maximum of the minimum?
The court could do that.
Well, no,
certainly.
but I'm asking for your
yes,
view.
If the court were to do that, I think the difficulty with doing that is the way these statutes, well, I guess presumably the court could, well, yes, it would give meaning to.
Right, because it would still be a minimum term.
Right. But
would still define the upper end of the minimum term, and so would have some meaning. Not less than, as Rossetti says, is a minimum term. 2.5 is what comes after not less than. And then we also have this weird third sentence, which is 1. So 1 to 2.5 is the range for the minimum term. That gives every phrase in the statute a meaning.
Yes, Your Honor, I agree with that. I believe that, I would argue that a judge could impose for the minimum range of the sentence, a 2.5-year sentence. Of that sentence, 1 year would be mandatory.
Right.
And obviously, the higher range of the sentence could be whatever the court feels is appropriate. And as your honors know, the problem stems from the ambiguity in the statute. We have 3 classes of individuals, people who are convicted of the crime overall, and then it bifurcates them into 2 further distinctions, those with FID cards and non-FID cards. I would argue that if the court were to allow the construction or interpretation of the statute that we're proposing, it would give meaning to the statute, the entire statute, and give a judge discretion in dealing with anyone who falls into any one of those 3 categories. There's also a public policy argument that could be made in defense of the position that we're proposing.
And what would that be?
Well, minimum mandatory sentences obviously reduces the discretion that judges have in deciding these cases, or crafting a sentence that they feel is appropriate given a person's background and given their history. By giving trial judges more discretion, and I believe the statute as interpreted in Rodriguez, which I believe is a good compromise, it gives those judges those tools that they can use.
But they would still have that even under that construction, because you would still have on the low end, you have to give at least a year, but on the high end, you have anywhere up to, you have up to 2.5 years, right?
Right. I guess my argument would be that if we increase the minimum mandatory sentence, that would be further tying trial judges' hands in crafting a sentence. It's understandable where a judge can be faced with a situation where there's a defendant where it's appropriate to give them, as in our case, a 1 year to 1 year and a day. So we would argue that there's the statute being ambiguous and Rodriguez being a good compromise of all the terms inside the statute, that the court should allow or adopt the construction or the interpretation of the statute that we're proposing. Thank you.
Okay, thank you very much.
SJC 13798, Estate of Caroline H. Walsh versus Commissioner of Revenue.
Good morning, Your Honors.
Just 1 second, okay? Let's let everybody get settled. Thanks.
Good morning, Your Honors.
One moment. Okay, Attorney Revere. I'm sorry, Attorney Walsh, please.
Good morning, Your Honors. Michael Walsh on behalf of the estate of Caroline Walsh. With me is my law partner, John Walsh. If the court is all right, I intend to focus my argument on the constitutional questions, particularly Article 26.
Can I ask you just to slow down?
Yes, Your Honor, most certainly. I will attempt to focus my arguments primarily on the constitutional arguments, primarily Article 26, if that's all right with the court. I know there's some statutory and evidentiary issues in the briefing, and I think the briefing covers that pretty well. The heart of the argument in this case is that the formulaic penalties adopted for late filing of tax returns or for the late payment of tax returns contravene what this court should interpret Article 26 of the Declaration of Rights to encompass. This court recently sort of freed the excessive fines portion of Article 26 from the cruel and unusual punishment section in the Raftery case.
Can you explain to me how interest payments are punishment?
The Commonwealth has the better part of the argument in that interest is remedial, but to some extent also penalties are remedial. And the Commonwealth would, the Commissioner would distinguish between.
I want you to address it. You argued that interest payments are covered by Article 26. I'm wondering how that can be when you're renting the government's money.
I argued in the reply brief, Your Honor, that interest alone cannot stand as a penalty, but that when it is fused with a hefty, very hefty fine or penalty.
Okay, that's a separate inquiry. I want you to focus on, we have two provisions here. We have the interest payments and then the double penalties for late payment and failure to pay. How are interest payments?
There is the statutory issue where the penalty shall include the interest. But beyond that, to answer the constitutional question, the Commonwealth does have the better argument that the interest is not in any sense a constitutional fine.
All right, I'll take your non-concession concession.
Thank you. We urge this court to adopt, noting that the language of Article 26 is identical substantially to the 1688 Bill of Rights from England, we urge this court to adopt a test from the Magna Carta, which treats small fines as subject to a general proportionality and then has a greater inquiry for what the Magna Carta refers to as greater faults. It is our argument more or less on the idea that $100,000 is a lot of money, that this is a greater penalty and that therefore it should have been subject to a more searching inquiry. There is an extensive briefing about the case law and the court should adopt all of the concerns that the Magna Carta reflects about not impoverishing people. I don't know how well the facts are briefed on that in this case.
We wrote a lot of pages to the proportionality test, right? So why don't you apply it here? So
Yes, Your Honor. So in particular, in the heart of our proportionality argument is that we borrowed from the federal Supreme Court in Bajakian and argued that one of the things that the court did there was they looked to federal criminal statutes that cover similar conduct. And so we have in our principal brief a list of similar statutes, including the criminal statutes for failing to pay an estate tax or avoiding an estate tax. And the fines in those cases, the criminal fines in those cases are $1,000 or $5,000. And we argue that the mechanical formula the civil penalty that came out in this case being more than $100,000 is simply well in excess of the kind of criminal fines that the legislature has prescribed for similar conduct. And so we believe that that's sort of a legislative statement about policy as to how grave these harms are, and that should inform the court's proportionality analysis.
How do we take into account that there's a cap on both statutes and that the dollar amount of the fine is proportional to the tax loss?
We argue on the statutory side, we argue the cap was inappropriately applied and that we should have gotten a greater benefit. On the constitutional side, we argue that the cap is much like the mechanical formulaic penalty nature themselves should be thrown out, because at least in this case, they amounted to a greater offense under the Magna Carta standard rather than a lesser offense. And so at least as applied in this particular case.
Before we get to proportionality, don't we have to decide if this is a fine?
You do, Your Honor.
Okay, and so can you address why this is a fine?
Your Honor, this is a fine for not having done something that the government wants done, and therefore you are...
No, but I think that there's a definition about fines, isn't there?
There are several definitions. One of the ones that we cited to Your Honor came from the Russell versus Hanscom case, and I think it was 1854, cited in our brief, that says that a fine may be many things more than just simply a pure criminally assessed financial exaction. It may be things like restitution. It may be significantly broader, and that has been this court's jurisprudence over the last couple of hundred years.
That tells me what it's not. Tell me what it is. What's the test? I thought there was a test.
There is a test, drawing from the federal Supreme Court. The test is whether or not the fine is in any part a function of punishment.
Okay, and so address that. How is this punishment?
This is a punishment because when you do not do what you were supposed to do, file your estate tax return on time or pay the tax on time, you are subject to a direct exactation, a forceful exactation from the government, one which the government will collect no matter how it wants to, or will eventually collect.
Do we have Circuit Court of Appeals dealing with tax penalties as being fines under the Constitution?
We do, Your Honor. There's actually a circuit split on that topic. We cited, I believe, to an Eighth Circuit case. The commissioner cited to a First Circuit case. There is also a couple of new, I think there's a brand new 11th Circuit case since the briefing was done, if I remember correctly, that addressed this. And the short answer is it appears to be a relatively open issue of law, Your Honor.
On Article 26, what do you do? The department points to the fact that that language differs from the Eighth Amendment and requires that the fine be imposed by a magistrate or a court of law. And here, neither of those two things has happened. So what do we do with that?
Your Honor, because as we argued in our reply brief, if you follow the commissioner's analysis all the way through, it would convert this into a bill of attainder where you would have the legislature imposing fines. It also sort of turns on its head all of the court's jurisprudence about mandatory minimums, because that would essentially be the legislature imposing a sentence, not a court after adjudication.
We have case law that defines magistrate more broadly. I did some looking because you guys didn't either cite McDuffie. McDuffie has a long footnote describing what magistrate means, including that in Article 5 of the Declaration of Rights, we talk about magistrates as referring to legislative, executive, or judicial branch. So we do have case law in your favor.
Always appreciate, Your Honor, the footnote. I didn't cite the footnote, Duffy. I did draw from some of the sources that cited.
It's footnote 16 that clear that magistrates refers to executive branch, but it may refer also to the legislative branch as well. So,
in which case, Your Honor, to answer Justice Waholian's question, the short answer is that fines are non-remedial exactions imposed upon someone for a punishment. Essentially, Your Honor, may broadly lump all government financial transactions into fees, taxes, restitution, or fines. And since this is not a tax or restitution, it is a fine, or at least...
How do we determine whether it's a punishment versus a deterrence?
Your Honor will recall that deterrence is one of the important underlying aims of the criminal justice system. And so to the extent that it is deterrence, that may be very much a fine.
But wasn't it remedial in the sense that there's a lot of investigatory resources in policing this kind of failure to file, failure to pay, right?
The federal Supreme Court has some useful case law about, to some extent, all fines are remedial to cover the cost of enforcement. But even in this specific case, Your Honor, that would sort of allow the Commissioner of Revenue to double collect, because as Your Honor was, Justice Gaziano was just talking about,
that's the
interest.
time value of money. That's a cost to the government. That's different than the affirmative cost to pay employees to go out there and find people like your client who aren't paying their fair share of the taxes that they owe to the Commonwealth.
The estate did come forward in this case, Your Honor. So they weren't found in any particular sense. So the extent that rationale would apply, it would not apply in the specific case. To the extent that it's remedial, the federal Supreme Court has excellent case law about, in some extent, any criminal fine or any civil fine is remedial, and therefore you can't weigh that particular factor too heavily.
And is there federal law saying that any tax penalty is a fine subject to the Eighth Amendment? You said there's a circuit split.
Yes, Your Honor. We cited an Eighth Circuit case in our brief, and I believe the Commonwealth cited.
And so tell me a little bit about the Eighth Circuit case.
The Eighth Circuit case is a new law that was enacted to force people to recover money from bank accounts overseas, and if they failed to disclose it within a certain period of time, they were automatically subject to a very hefty penalty, which was
if you failed to disclose it for 2 years in a row, the entire amount of that foreign account was forfeited. So is there a difference between that law and the kind of capped penalty that's at issue here in terms of whether it's a fine for purposes of the excessive fines clause?
I don't think so, but there is certainly logic there. We don't see so because we think that the important difference here is that it's a mechanical allotment. Instead of going up before a judge or a tax board and saying, well, Your Honor, my failure to file was because the accountant died, whereas that guy's failure to file is just because he's a jerk.
Do we require that level of ledgering by the government in order to exact the costs, for investigation? I thought the test was much more, is it rationally related to these costs? Or am I wrong? I mean, you're the expert.
And if it wasn't a fundamental right, like a right against excessive fines, that would definitely be the test, because there's an excessive fine involvement, and we argue it's a very large fine.
No, but again, it's a fine. I'm still at, is it a fine? And so the question on whether or not it's a fine is defined, I think, a little bit by this rational relationship between what the government is exacting, capped at 25% here, versus that other federal reporting, which is not capped, and it takes up the whole thing.
It's still a financial stake rather than a carrot to encourage the people to comply with what the government has set as a standard. And if you fail to comply with the standard, you suffer the consequence. And that is, at least in general, what fines are. It certainly isn't a tax to the extent that it's remedial to the government. It's not purely mechanical.
I ask you to address the argument that, and I'm going to say the name of the case wrong, Bajakarian, right?
Yes, Your Honor.
Whatever. It was tied to a criminal conviction, and that seemed to play a big part in Justice Thomas's majority decision in that case.
It did very much, but the federal circuit courts that have followed on from that have not lent the criminal capacity as much weight because they looked at the purely civil nature of it.
But the First Circuit has.
The First Circuit, and I think it's Levesque.
And Toth.
Or Toth, excuse me. Yes, Your Honor. I stand corrected. That's the other First Circuit case in the filings. In Toth, it did, but in the Eighth Circuit looked at it as simply as a mechanical fit, as a constellation, and it weighed the fact that the prescribed conduct was criminal rather than merely civil as indicative of more serious or fitting the proportionality inquiry, but it didn't necessarily knock you out of the ballpark from whether it was a fine or not.
Assuming it is a fine, can you just talk about why it's excessive if, as Justice Gaziano pointed out, it is capped, and then also looking at the behavior, the 7-year lapse in payment or filing?
Yes, Your Honor. Assuming that it is a fine, it is excessive. First of all, if the court is inclined to adopt the Magna Carta lesser fault, greater fault analysis, it would fail the greater fault test. Even if it meets proportionality, we don't think that there was any wiggle room to assess whether or not, because the formula is applied mechanically. It doesn't, if I were a poor pauper and the penalty could be more than I could ever afford, and that kind of lack of individualized inquiry, we think would doom it.
The poor pauper wouldn't have $100,000 in tax liability.
Another problem, Your Honor. As Your Honor knows, the estate tax is fixed on a on a graduated percentage basis. I don't think the value of the estate is in front of the court, but it's not hard to surmise it's somewhat extensive. In terms of whether or not the first problem is the penalty is mechanical. It doesn't have any room for relief as Magna Carta.
Well, isn't there relief through asking for a reduction in the amount?
That's one of the other places where, when you measure the statute against what we perceive the Constitution demands, that the statute fails, because the reasonable cause test that the Appellate Tax Board engaged in, the statutory relief valve, requires the burden to be on the appellant, and it requires them to show cause. We cited to a law review article by one of the nation's leading Eighth Amendment scholars, Beth Colgan, and I believe in our reply brief, to argue that the burden of proof should be on the government, that it's perfectly fine to raise the burden of raising the claim upon the appellant, but to put the burden of proof on the government is where it should belong.
How's the government to prove that you had a good faith delay?
It's the government. It should be the government's burden to prove that. It should be a shifting burden formula like McDonnell Douglas. The government should have to raise the first set of circumstances that there was a failure to comply, that they think there was no good cause for it, and then the burden should be on us afterwards to rebut it. I believe that's one of the things that Professor Colgan's article alludes to. On that, I'm out of time, so I'm not sure if I should address anything else.
No, I think that's good.
Thank you very much.
Thank you. Okay.
Thank you, thank you, Your Honors. May it please the court, Grace Golke, Assistant Attorney General, appearing on behalf of the Commissioner. Your Honors, the Commissioner is asking this court to affirm the decision of the Appellate Tax Board as supported by substantial evidence, free of legal error, and consistent with constitutional protections. And I will also focus on the Eighth Amendment, Article 26 issue, unless the court has questions about any other claims. Even if we assume that both the Eighth Amendment and Article 26 could apply here, I understand interest appears to no longer be at dispute, so we're talking just about the statutory penalties. Those penalties are not fines under the jurisprudence laid out by this court and by the U.S. Supreme Court. This court in Betancourt described how a fine must be an extraction of payment, which we will concede is true here, but that is punishment for an offense. And it described the Supreme Court's description of a fine in Bajikagian as characterized by an extraction of payment that is imposed at the culmination of a criminal proceeding and requires conviction of an underlying felony.
It was clear in that case that there's a close connection to criminal penalties, but it looks like the feds have got a split going on in this. Do we have Old English cases, for example, where the Crown imposed these tremendous civil penalties and they applied, these all have a distinct history, and they were designed to prevent the Crown from imposing these, huge penalties on the people the Crown didn't like. I don't know if they drew the criminal civil distinction as clearly as you're doing, particularly because the third clause deals with corporal punishment. So do we have any, he loves going into history. Did you do the same kind of historical analysis about whether in England or in the colonies these kinds of fines were deemed to be excessive?
Your Honor, I don't have a historical case. I do know that the U.S. Supreme Court in Bajikagian did do a pretty extensive historical analysis, so that would be one place to look. And what they came out with was that civil penalties that are sort of collateral consequences of a criminal conviction were fines. They did not go so far as to say that any civil payment would be a fine under the Eighth Amendment. Now, there may be other constitutional protections.
Why wouldn't an excessive fine, if someone were you know, if a civil penalty imposed some gigantic, and it's a penalty, right, which has a punishment component to it, why wouldn't, I just don't know if the criminal-civil divide is as clear in the case law. And unfortunately, spent a lot of time reading all that old case law. So it looks like it's sort of an open question whether this is a fine.
Maybe assume there was no cap here, right? And it was a 100% fine for the tax liability. Would you be making the same argument?
Well, the First Circuit in Toth was looking at a different regime that can accrue sort of year over year such that it will actually exceed the value of the foreign account. It's a slightly different structure there. And they said even in that case, it was still a remedial measure that did not qualify as a fine. So I don't think that is the distinction for Eighth Amendment purposes.
You have two different penalties for the same offense conduct, right? Or the same civil violation.
Well, Your Honor,
one is failure to pay and one is failure to pay timely.
Your Honor, one is failure to file and one is failure to pay. Right. And there are situations where those may be disconnected. So sometimes a tax form will be filed, but the payment will not be made, or the payment will be made, but perhaps there was, it was misfiled, or those are two separate acts, and they are two separate harms. One is related to the information to the Commonwealth, the filing, and then one is connected to the actual monetary payment, the payment. So they are serving distinct purposes.
But they aggregate.
They do aggregate, yes, Your Honor. And perhaps if there were 6 different activities, and so the 25% could exceed 100. Again, I still don't think it would be under the Eighth Amendment.
How about a hypo? Say you don't pay your estate tax, you got $1 million penalty on top of that. Wouldn't that be an excessive fine under the Constitution? Particularly if it involved, estate tax of some, person with a very small amount they're inheriting from their family, and they're getting $1 million put on top of that. That would be an excessive fine, wouldn't it?
Well, Your Honor, obviously there's a number of reasons that that's unlikely to occur just based on the statutory structure.
I'm just trying to figure out whether we, as Justice Wendland says, okay, we got to look at the facts here to decide whether it's a penalty, a criminal fine, a fine, excuse me. And at a certain level, it's going to be a fine. The penalty is so high that it's got to be unconstitutional.
Well, Your Honor, one piece would be the remedial aspect of if the amount were so disconnected from what would be the reasonable cost of loss and investigation, that could take it out of that.
We don't have any basis here to determine that penalty provision was based on how much it costs you to track them down. It just looks like it's a hammer to prevent this kind of dilly-dallying.
You're not saying that there's no punitive element to this, are you?
Your Honor, I would say that there is a sort of incentive element of it, certainly, which could be viewed as punitive. But I would say even if this were considered to be a fine, that it is not excessive. So in this particular case, we do not have, even if we have a fine, it is not an excessive one.
Why not? Because it's not, what's the evidence that it's proportional to the government's remedial interest?
Well, Your Honor, that I think would go to the question of whether it's a fine. Is that the question? Versus the excessiveness is the proportionality to the conduct as opposed to the proportionality to the investigatory interest.
So how do you measure that?
The proportionality to the conduct?
Yes.
So the proportionality to the conduct here, I think there's at least 3 ways in which this is by its face proportional. One is that and by its structure. So one is that it is always proportioned to not only the underlying tax loss, but also sort of by extension to the amount of money at issue. So an estate tax is only owed at the time it was $1 million, now it's $2 million. And then from that, there is a proportional amount that is due as a tax. And then from that, there is a proportional amount that may accrue as a penalty. So you're always
the 1% is tied, is what's the base on
the 1% is tied to the tax liability,
okay,
which itself is already, of course, just a proportion of the actual
State value.
amount at issue, or the size of the estate.
Cap is what saves you, doesn't it? The cap is the 25% cap. It's hard to say that something is when someone isn't paying what's owed, and it gets a little more problematical. This argument I don't think is made. When you add all these four things together, it starts getting. Does it exceed the amount? I'm just trying to. You've got interest plus the 25%. What is the total amount in stake, and what is the total penalty here, and interest and everything else? What does it all add up to?
So at the time of the assessment, I have it here, Your Honor. At the time of the assessment, the statutory penalties, and I'll just round for ease, were about $112,000. The interest was about $145,000. So it added up to $246,000. The estate tax was $224,000. So the combined penalties and interest were greater than the underlying liability, but that in large part is due to the interest.
That's what sort of makes, although I don't know if we have that argument exactly. It's just when you add all four of these things together and it exceeds the amount of the tax, then it gets a little more complicated.
Well, Your Honor, I think we certainly have to disaggregate the interest and the penalties. As I heard opposing counsel appear to concede, the interest serves explicitly a remedial purpose just related to the time value of money. That really isn't changing the amount. It's just reflecting the passing of time. So really, we should just be looking at those statutory penalties, which are always going to be capped at 50%. And I would add that the second way in which this is proportional is that it is tied to the length of delay. So you're only hitting that 50% if you've delayed 25 months or more. Someone who delays only 1 month, it only is going to have 2% if both of them apply. So it is proportional in that manner again. So it's proportional in amount and it's proportional in time. And then it is also proportional to the conduct itself because of the provision for abatement where there was reasonable cause for the delay. That is incorporated. I would add, I think, a fourth category, which is that.
One other thing that helps you is the two pension cases, the ones we've decided, at least Rafferty, the amount of lost pension well exceeded the criminal penalties, right?
Yes, Your Honor, precisely. So in Rafferty, it was a $1 million forfeiture. In Finneran, it was a $433,000 forfeiture. Maher, I'm not sure the pronunciation, was $576,000 in that case, they said a potential gain of 125. So we're talking about orders of magnitude. In Betancourt, which was obviously a case where this court did find an excessive fine, it was 60 times the amount of the criminal fine that was forfeited. So we're not, even if we're near sort of a one-to-one, which we're not if we're only looking at penalties, even that is well below what this court has considered grossly disproportionate, which is the standard here laid out by both the Supreme Court and by this court. And I would add just that the consideration of whether a fine, assuming it is a fine, whether that would leave someone destitute, it really just isn't presented by the facts of this case. So to the extent this court is interested in considering that question, this just isn't the case to do it. If the court has no further questions on either the Eighth Amendment Article 26 issue or any of the other claims raised, the commissioner will rest on his brief.
Okay, thank you very much.
Court, all rise, please. Hear ye, hear ye, hear ye. All persons